forth, Attorney Dennis Marenbach, a known criminal attorney, and you have been very helpful in shedding some light on the insights to the criminal proceedings and what happens in and around the court system, especially with regard to the Michael Jackson case, to help the public understand as clearly as possible this process. There's a lot going on in this case, and a lot that has been said that a lot of people either don't understand or are just now learning about. So I want to thank you for doing that. Today, after the indictment came down yesterday, I'd like you to shed some light on what the grand jurors were able to or are able to talk about, if anything, after this proceedings, and what they told possibly the presiding judge when he showed up yesterday afternoon to hear what they had to say after the many, many days of hearing witnesses. So what happened yesterday?
Well, I think we have to, first of all, start off with the juror's oath. The juror's oath is instructing him as a matter of law that he's not supposed to speak to anybody about what went on in that grand jury room unless required to by the judge. So that's an absolute secrecy, and you're not going to know anything that happened until that indictment is open. When they went down there, the judge asked the jury, "Did you come up with a bill?" And the foreman would say, "Yes, we have." Then he would look it over for form. He's not there to second guess the jury. Once he sees the proper form has been made, he then orders that it be sealed. He then orders that the grand jury be discharged, or maybe not discharged. They may be sent on furlough in case at a later time more information needs to be brought in, because we never know that. Then what's going to happen is on April the 30th, the judge, Judge Melville, is going to open that indictment. It's going to be presented to the public, to the defense team, and then he's going to enter his plea, as we know, of not guilty to whatever counts. They may or may not be the same counts. They may be more counts. We really don't know how the prosecution has decided to proceed in this action. Let me point out that after the indictment has been made, then a motion can be made to set aside that indictment for insufficiency of evidence, failure to consider exculpatory evidence, and a number of other legal reasons. Probably that's going to be heard in about, maybe 2 more months. The defense team will get a complete copy of the transcript. It will not be released to the public. It may be released partially, simply because it will be blocked out because of the protection of the various witnesses. And then he will have his motion in open court to argue why it should be that this indictment should be thrown out in part or in its entirety. After that goes on, if he fails, in my opinion, he will fail. He will then file for a writ of mandamus to the appellate court for the purpose of asking the appellate court to review the decision of the judge with the idea that that court will overrule the trial court. Writs are very difficult because they must be done on an emergency basis. 1 out of 10 are only granted, so it's a real long shot. But if it is granted, it will be heard within 30 to 60 days. After that, regardless of what happens, then it can be taken up to the Supreme Court of the state of California, and that would be the end of the road on that basis. I shouldn't say the end because in the law business, who knows? There obviously could be some collateral federal attacks. There can be various writs with the federal court raised on the basis of fairness, constitutionality, and things of that nature.
Between now, April 22nd and April 30th, even though no one has officially seen what the grand jury has done, there will probably be a lot of speculation as to what they came up with. You're saying on April 30th, the defense attorneys, the defendant, and everybody in that courtroom, that'll be the first time they'll actually hear officially what the indictment
That is correct. Was. Then it's supposed to be unsealed. Now, it's possible that the judge, because he has the discretion, could make a determination to unseal it before then and to let that become public knowledge. I'm sure some of the attorneys from the media will be asking the court to do something like that. But I think you're going to have a media circus that will be far greater and in excess of anything that we've seen before in Santa Maria for this one.
Mr. Jackson has to appear?
He absolutely has to.
This is an arraignment?
This will be an arraignment on all the counts in the indictment.
Do you believe that because we're at such a critical juncture that the DA might ask for a larger bail or some other type of procedure to make sure Mr. Jackson doesn't flee?
In my opinion, I don't think so. I think he's satisfied with the bail situation. He certainly has to be satisfied with Mr. Jackson's respect of the limitations that's been placed upon him. There's nothing to indicate that he will not appear. I think the bail will remain the same.
Mr. Geragos and Mr. Brathman did bring out the list of a lot of things, exculpatory evidence in the last hearing. They said they wanted that presented to the grand jury during this past proceeding. They can take some action to verify that that happened, or to challenge if it did or did not happen?
Absolutely.
That's
in fact,
a particular motion. What's that called?
That motion to set aside the indictment under 995 of the Penal Code, basically what they're looking for is every reason why these counts should not have come through as a true bill. One of them can be is the district attorney failed to present evidence which was presented to the DA by the defense, which would indicate that Mr. Jackson was not guilty. So then you have an evidentiary issue as to whether or not, first of all, did they even submit any of this evidence? Second of all, if they didn't, did they have to? Because there are rules for evidence, and those rules of evidence are completely contained in the Penal Code. It's been well briefed, it's been well litigated, and that's an issue which they will also raise.
The grand jury secret proceeding in this case, does that give the DA a little more of an upper hand, and that now this is going to go to trial, it looks like, or does that help the defense, and that really nothing has been out in the public yet, and they can still kind of craft their defense and use it for a later date?
Well, I think there's a number of points that we can consider. Why go to the grand jury? Well, the reason to go to the grand jury is, I think in this case, to obviate the need for a preliminary hearing. Now, at first, one might say, well, isn't that sort of unfair to the defense? But on the other hand, the people have a right to a speedy trial. And if they had to go through a preliminary hearing, and then with the motions to set aside, say, 995 Penal Code, we might be here for another 2 years before the case gets to trial. So he's shortened down the time from now to the time of trial, probably by at least a year, by using these tactics.
Judge Melville wanted the trial to take place this year. In your mind, knowing Mr. Geragos' schedule in the high-profile Scott Peterson case and some of the motions and actions that can be taken,
yes,
we're in mid-April. Lay it out for me. Is it going to happen in 2004?
It will not happen in 2004.
Why not?
It won't happen because procedurally, I think they have the right to exhaust any remedies that they have to set aside the indictment. We really don't know how long that trial is going to last up north, and he has to have a reasonable amount of time to prepare. And I think there's something important here. People say, well, why should we wait for this attorney to finish another trial? Well, we really respect the fact that a person should have an attorney of their choice. What is at stake here by a delay? Some inconvenience to witnesses, some inconvenience to the court, but let's balance that against not just a high-profile person, but let's balance it against what he's facing, 20-plus years in the state prison. I think that's as much as a death sentence for anybody.